Hello, everyone, and welcome to another episode of Common Law and Simple Flow. Today, we are going to talk about taxation, and we are going to continue the topic of inheritance tax. Let's continue with the second branch of the flow: business property relief (BPR). We have already spoken about business property relief in previous examples, and now let's delve deeper into it. Business property relief is a discount for business assets when working out inheritance tax. If the person owned the asset for at least 2 years, its value is reduced before tax is calculated. The ownership of 2+ years immediately before the transfer is your first check to do before evaluating the BPR. So the first thing that we need to check is whether the 2+ years are immediately before the transfer. But there is also another point that you should check. Previously, we were talking about the example when parents are leaving their apartment to their child or doing a gift transfer to their child of £800,000. All those examples were personal transfers and personal ownership. And this relief only works with business property. So something should belong to you as business. It works for gifts made while alive and for assets passed on at death. The examples will bring more clarity. The discount is either 100%, some assets are ignored completely, or 50%, half is ignored, depending on the asset type. Estate has 600,000 of qualifying business shares. This will get 100% BPR, business property relief, and £200,000 of a building used by the business, which will get 50% business property relief. Shares counted for inheritance tax are £0, and building counted for inheritance tax are £100,000, the half of the 200,000. So only 100,000 goes into the inheritance tax calculation before other allowances. This is just a general abstract example which roughly represents what is what in the example. But let's now figure out when it is considered when the shares qualify for business property relief. So they qualify if the business is a real trading business. It sells goods, services, and not mainly an investment business, not mainly holding, renting property, shares, or cash. Also, you need to have owned the shares for 2+ years. So to qualify, we need a real trading business. So you own a business. You are not just investing in someone else's business and have shares of it, but you have real trading business which sells goods and services. And you need to have that ownership for 2+ years. Inheritance of building used by business. If you personally own a workshop office that your trading business uses, it usually gets 50% relief on that building's value. If the company owns the building and it's used in the trade, the relief comes through the shares, often 100% if the shares qualify. So just to concentrate on these 2 points. If you own a building, a workshop or an office that you're a real business, which is separate from that workshop or business, just uses that, so it is still under your name, this building and workshop, and your business, which is separate, which is a separate legal entity, uses that building, then you will get the half of the relief, like it will be 50% of the relief. But if the company, the separate legal entity that you own, also owns the building, then it's part of the company and you will get 100% of relief. If a property is just an investment, for example, buy to let, not used in trade, there is no relief. When you buy something to give it as a lease, like you bought a land to rent it to some farmers, for example, then it will be just investment and there will be no relief. Now let's go back to the source and let's probably go to the right. Start with this 100%. For deaths on or after 6th of April 1996, business property relief at 100% applies to cases. So 100% relief applies when you own the whole business or share in a business. So you either own the entire business on your own. For example, you own a limited company, or just a part of it. For example, you are a partner in a partnership and your partnership share is considered your full ownership, like the part of the company, and it will be under 100%. Shares in an unquoted company. You own shares in a private company, and this is not considered as an investment, because if you are on a stock exchange company, the public company that mostly sells their shares to make to gather investments, this will not count, but shares in private company will count. And this also includes AIM company shares. This AIM shares are shares in companies listed on the alternative investment market, a market run by the London Stock Exchange for smaller growing companies, not the main market. So this alternative investment market includes the companies which are smaller companies. They are still public companies because their shares are publicly traded. However, they are 100% ignored for inheritance tax purposes because they are not listed on recognized stock exchange. But there is an important change from 2026, and this is important because this overrides what the second paragraph here says regarding AIM. Do AIM shares get 100% BPR? Historically, for earlier wording and for earlier cases, and yes, 100% BPR provided the company is trading company, not merely investment. The shares were owned for at least 2 years, and the shares are still owned on death. And regarding this not mainly investment, it means that the trading company is not a company that invests in other companies, so it is just allocating money. It is trading company that really sells goods and services. And here there was a mini misunderstanding. The business qualifies if it is a real trading business. It means that it is a business that sells goods and services and not an investing business that it, for example, uses cash for cash of others to invest in other companies, or maybe it is renting property or dealing with shares, like buying and selling shares, etc. So it shouldn't be just reinvestment company, but should be a real business that does stuff like selling goods and services. And coming back here, the company here again must be a trading company in AIM, Alternative Investment Market. And there is a change from April 2026, and it's very important because the AIM shares, they were really popular and attracted many investors because there was 100% inheritance tax relief. Because we can think so, it was very risky. And then if you understand, okay, I will invest in small companies, it's risky, and then I will need to pay 50% tax on inheritance, that's a bit unfair. But yeah, now the unfairness is official, and the alternative investment market shares no longer get 100% relief. They get 50% BPR only, business property relief. So the earlier text is correct historically, and if there are cases for earlier times, the death before 2026, then it will work. But the text needs updating for deaths on after 6th of April 2026. So now let's go back, and you understood that on the death cases for after 6th of April, we have this whole business concept that if the business is trading, you have the whole business, and you have partnership as well. Your partnership also gets 100% discount. So now let's continue on this direction. Quoted company shares, securities that you controlled. Quoted are the companies that are listed on a stock exchange, and controlled are companies you had control, normally more than 50% voting power immediately before the gift, death, and the result is that only half their value counts for inheritance tax. So for quoted shares, the listed companies, basically, the business property relief only applies at 50% if the deceased controlled the company, typically more than 50% of voting power. And important is the voting power and not the shares. This means if you have 20% of quoted shares of public listed company, you don't get a relief because you don't have control. So important is the amount of control that you have over a public company, and it should be more than 50%. So the public companies usually go with 50% relief, especially if you have more than 50% of voting rights. But if you don't have this more than 50% voting rights, you don't have any relief. Now let's talk about assets you personally owned, but your trading business used. We have already talked about this. When you personally have a land, building, machinery, plant that you own as a person, but they were used in either a business where you were a partner, or a company you controlled, or a trust where you could benefit and the assets were used in your business. Result is only half the assets value counts for inheritance tax. So here is important distinguishment that something, a business that you own personally and you control it. For example, a listed company that you control, you will have 50% of inheritance tax relief. But let's say besides of that company, you also have a building, and you give that building as an office for that public company that you are controlling. In that case, in other normal cases, the building would be like you don't get any relief because it's your personal individual property and there is no business there. And if someone else is using your building, like you're renting it to a third-party company, then again, still you don't pay any, you don't get any relief from here. But if your business was using your personal asset, then on the inheritance tax cases, you will get 50% discount. Amazing. So now let's go to the main crossing part where we stopped. So the discount, as we said, is either 100% or 50%, half ignored, depending on what we have just discussed. Now, I think it's just an example. The setup is Alice personally owns the bakery building. Her trading bakery business uses it. She owns it 2+ years, the bakery building. Alice dies. The building passes to her child. The business property relief says following. The building is a personally owned asset used in Alice's trade, so it gets 50% business property relief. If it was used by a third-party bakery and it wasn't Alice's bakery, then it wouldn't get any business property relief. But in this case, since Alice was using the bakery the building with bakery business that she owned, then it's 50% business property relief. Only half the building's value is counted in Alice's estate for inheritance tax. So building worth 400,000 now is 200,000 pounds for the sake of counting the inheritance tax. Another setup. The company Bakery Ltd owns the premises. Alice owns shares in Bakery Ltd and has held them 2+ years. Bakery Ltd is a trading company. Alice dies. Her shares pass to her child. BPR on shares, usually 100% for unquoted trading company shares, including most AIM. But this will be an exception from 2026 April. So if your company is a limited company, then you must check if it is AIM or it is not AIM. The share value is ignored for inheritance tax. The effect is the value of premises is relieved indirectly through the shares. So if you own a private company here, if you died after 1996 and you have the whole business or a share in business, and here the share is not specified, how much is the share? So the control is not important. You either own the entire business or just a part of it, including your partnership share in trading partnerships. So if you are partner in a partnership, you have a share in a business, like 30% of the shares or 5% of the shares, then it will get 100% relief if it is a limited company. And you see Bakery Limited Ltd is limited, and it's doesn't work for AIM. The AIM will be 50%, but only after 2026 you need to pay attention when the person died exactly. Now, when the relief doesn't apply, and these are the common pitfalls. Firstly, the business is mainly investment. For example, property letting investment company. It's not about how you behave yourself. So you think, okay, I'm doing an investment when buying shares of this business. No, it's about what business actually does. If the main purpose of business is investment, that they are investing in other things like other companies, or they are leasing, renting properties. If the topic of the company is investment, this will not work because it would be just a good way to store your money. So you are just parking your money there in order to safely pass it to your children. The assets is not used in the trade. For example, empty or led to a third party without being part of the trade. This is a bit unclear. It is meant that the asset that you own in the business that you have invested, it is not being used. So it's being set on the side without any risks. So the thing that you own in the business should be actively used in the trade. And also in the same logic as parking your cash, you shouldn't park your assets there. Expected assets, surplus cash not needed for the trade, don't get relief. Again, if there is like cash, extra cash that the business has generated, it belongs to you and it doesn't really used in trade. It's a way to park your cash. You need to understand the mindset logic of the legislator. The whole idea is that you do not hide your investment, just park it in a business so that it's safe and you can, with 100% relief, pass it to your children. No, it will not work in that way. The owner hasn't held it for 2 years. This is the first and most important thing. You need to check if there is just 2+ years immediately before the transfer. If you own something for 6 months, this will not count. Or if you had a break, like a small pause, and then again your ownership continued. The business stopped trading before the death. So if the business stopped trading, it means that they are not trading at all. So it's again behaves like a way to park your cash. You are not investing your money and risking your money. It's all about the risk that you have invested money, which is under a risk. If a person dies and has unpaid salary, which he did not receive, there won't be any question whether it gets business property relief, as it is not property of the business. It belongs to the deceased person. It will be part of the estate for inheritance tax, with 14% taxing at its full value. This is subject to the usual nil rate bans relief. So the salary is a tricky part. You may think, okay, this is an asset which is part of my ownership in business, but it's not an investment in a business. The salary is something that should eventually land on your personal private account. It's for personal private use. It's not part of a business. That's a straight boundary between what actually is your business and what is your personal, and salary is personal. That's why it will be taxed under 40%. So we have covered this branch as well. Sorry, we are going a bit slow because the topic itself is not so easy. We need to cover all the details. So we have talked about business property relief, but there are cases when business property relief doesn't apply. So let's see what are those cases. The first one, it's mainly an investment business. If the business is mostly about holding investments, for example, shares, securities, rental property, cash, and they are not trading goods. We have talked about this several times, and this is very important. Your business needs to be trading. They will need to sell something, create something, provide something like a service, a law firm, or producing some goods and selling them on Amazon. Even if the company is a partnership, but they mainly invest in other companies and hold shares and stocks, this is considered as an investment business and won't apply for BPR. So we don't say all partnerships will work. No, if the main purpose of the business is to invest in other companies, is to work with shares, work with cash, then it's not a trading business, it's an investment business. A company that mainly owns buy-to-let flats and collects rent, no BPR. So if you're just collecting rent, you are giving your territories, your lands to farmers, and they are just paying the rent to you every month. That's not a trading business, that's an investment business. Secondly, the BPR, business property relief, won't apply if it's not for profit. Charities or other non-profit bodies don't qualify. So if you think that you have a charity or non-profit organization and it will pass to your child with a tax relief of 100%, that will not be the case. The BPR will not apply for the companies that do not aim for profit because they are not risking anything. A company that mainly owns... Let's continue with the next one. There is a binding contract to sell the business. If at death transferred, the business is effectively already committed to be sold, BPR is blocked. Let's understand why. Unless a buyer is a trading company that will continue the business and the seller is paid wholly or mainly in shares of that buyer. This is very nuanced exception, and the whole part of this binding agreement. So if there was an exchange of contracts and the contract became binding, and there is a death of the person who owns the company which is being sold, and at the point of the death, at the time of the death, there was this contract, there was a commitment to sell it, BPR is blocked. Why? Because the contract officially, this asset that they have, business asset, is now cash. Doesn't matter that the cash has been transferred or not. If the contract is binding, it means if there was an exchange of contracts, then the building is considered to be converted to cash. or any other asset. And we know from the salary example, if you are receiving cash, it is not a business asset. Cash is cash. Salary is salary. You have to tax your money with the maximum inheritance tax, which is 40%. But there is an exception. If you're not receiving cash, and this again stays in our logic, if you are getting paid in shares of the parent company that is buying your child company, then the BPR will apply because you are getting shares in a business that will continue trading. Important is that the business stays the same and continues to trade. Basically, you are still owning the business, but you are not owning the business directly. You are owning shares of the company, the parent company that owns your business. So if you have signed a sale contract to a trading buyer where you will get mostly shares and the trade of the company which is being sold will continue, you will still get the BPR, business property relief. Why you will get it? Because you are keeping your business, but indirectly. And then you will get your 100% relief because it was your limited business. Okay, there are still many points to cover. Let's continue. The company is being wound up. If it is in a liquidation, if the company is in liquidation, BPR is blocked. Unless the winding up is just a step in a reorganization, so the same trade continues. Company being liquidated to distribute cash to owners, no BPR. Liquidation is part of merger to keep the business going, may still get BPR. You get the logic. It's the same logic. In the liquidation, the owners, the shareholders will eventually get paid if there is enough money. If there is no money, then the shareholders will not be paid. But the idea is that liquidation again converts the company into cash. And if we're talking about cash, then cash will be a subject of inheritance tax 40%. But if the whole purpose of liquidation is, and if like this doesn't happen very often, but if the whole purpose is just to reorganize the debt structure, to reorganize company, but still continue the same trade, then the BPR will apply because the trading continues. Just to understand the logic, if we're talking about continuing the trade, after selling, after liquidation, then we get the relief because the business stays as it is and we continue to own it. But if we are talking about cash, the salary, then it will be taxed under 40% inheritance tax. The next exception, when the BPR does not apply, person also qualifies for agricultural relief, AR. You generally can't double dip. If it's agricultural property, you claim APR, agricultural property relief, first. And you skip the BPR, business property relief. In hand working farms, normally you get APR at 100%. The agricultural value of the farm is ignored for inheritance tax. If the transfer happens before death, APR is applied to that lifetime transfer too. So no inheritance tax arises on that asset, even though the donor died shortly after. So it's not so that in the individual inheritance situations, if you die within 7 years, then you still pay the tax. And if it's after 7 years, then you pay nothing. But in agricultural property relief, you get 100%. Doesn't matter after death or shortly before death. Transfer the farm before death, 50% APR. Ben owned UK farmland for 7+ years, but led it to a tenant farmer. He didn't have vacant possession. He gifted the land to his daughter 6 months before he died. As it was used for agricultural throughout the 7 years, but let, so it was given for a lease, the gift qualifies for 50% agricultural property relief on the agricultural value at the date of the gift. APR is 50% mainly when the owner does not have and can't get vacant possession within 12 months. Typically because the land buildings are let under old protected farm tenancy. If you don't have a possession of the farmland, then you get only 50% of APR. So you have the ownership, but you don't have possession because someone is leasing it. Common 50% cases are let under an old-style agricultural holding act, AHA Act, tenancy that began before 1st of September 1995, and the owner has no right to vacant possession within 12 months. Reversionary interest. You own the freehold, but someone else has the right to occupy for now, so you can't take possession within 12 months. So if you are the owner, but you didn't have possession for the last 12 months, then you get only 50% APR. Keep the farm, 100% APR. Amira farmed her own UK farmland and farmhouse in hand for 10 years and kept them until she died. Because she occupied and used the property for agricultural purpose in the 2 years before that, the agricultural value of the land and buildings gets 100% agricultural property relief. So again, important is this 2-year period, which is our indicator and the first check for the business purposes, and for agricultural property relief, the 2 years of possession and occupation is the same. APR, agricultural relief, needs the land to be used for agriculture in 2 years before death, or owned for 7 and occupied for agriculture throughout. So important are 2 years of use for agriculture, or you have owned 7 years the territory and you have occupied for agriculture throughout it. So to be honest, it's very similar to each other. And since 6th of April 2024, APR only applies to agricultural property in UK. So this is only about UK land. It no longer applies to property in the Channel Islands, Isle of Man, or the EEA. It means that if your asset is in New York, the APR won't apply. But BPR isn't restricted to UK assets, and it would apply. So this business property relief, if you have a business outside of UK, still the relief will apply. But for the agricultural purposes, only the lands of agriculture in UK can trigger the APR. And if you fail with APR, you have, for example, agricultural business outside of UK, APR will fail, but BPR isn't restricted to UK assets and it could apply. All right. Now the last 3. Not mainly used in the business in last 2 years. This is straightforward. If the asset wasn't mainly used for the trade during the last 2 years before the transfer, a gift or death, no business purpose relief. A machine sat idle let to someone else for most of the last 2 years, no BPR. So the machine wasn't used, or it was leased to someone else, so it was not used for business purposes. That's why it will not get any BPR. No need for future use. If the asset isn't required for the business going forward, for example, it's surplus, excess, for example, cash is not needed, equipment is not needed, assets are not needed, then there is no BPR, aligned with the previous logic that we have. So surplus cash or an extra warehouse the business won't use is no BPR. The assets should be under risk so that it can work. Part use can qualify. If part of a larger, otherwise non-qualifying asset is genuinely used in the trade, that part can get BPR, usually by apportioning the value. A building where the ground floor is the shop, the trade, and the upper floor is a private let investment. The shop portion may get business property relief. The let portion will not. Okay, we have covered the third biggest branch and now the last tiny one, expected assets. In the business property relief, expected assets are things inside a business that don't really serve the trade, so they don't get business property relief. So it's another exception, basically. Let's now understand what is expected asset. An asset held by the business is expected if broadly it wasn't used wholly or mainly for the business in the last 2 years before the transfer, and it's not required for future use in the business, or it's held as surplus investment, excess cash, or a let out flat, a portfolio of shares rather than for trading purposes. So it's a surplus, something that is extra and sitting there without no use. Or it's mainly for the personal use of the owner. For example, company-owned holiday home the owner uses. Wholly or mainly equal are more than 50% for the trade. So wholly is when you use it 100%, and mainly if it's more than 50% of the use. So it's something that we have already covered in the previous descriptions. What happens if an asset is expected? And expected asset is like a parent name for that we just need to keep in mind. No business property relief on that asset's value. So there will be no business property relief on that. For shares in a company, business property relief is restricted proportionally. Relief applies to the trading value only. The expected part is carved out. So if part is used for the trade and the other part is not used, is so to say expected, then we do not apply the BPR on the expected part, and we apply BPR only on the trading part. Personally owned property, building or apartment not used in the trade of the firm, not used wholly or mainly for the business, will not be subject for BPR. So there will be no BPR. And if it isn't agricultural, no APR will apply either. The agricultural property relief. So it's about the personally owned property. When you use personal property, it will not be target for BPR. The personal property can only be target for BPR if you used your personal property with another of your business, or if you have used it for agriculture. That's the main exception. So we have covered the whole inheritance tax. Altogether, 2 videos are around 1 hour. It was not a big topic, but it was complex and had many tiny details. I hope you have enjoyed it. Thanks for watching and see you in the next episode.